And welcome back to Attorneys on Call. As we said, at any time during the program, please call the 800 number or go to whitleylawfirm.com. Ann Oxner and Ben Whitley in studio with us. And Ann, let's talk a little bit about, I know an area that you've been working on, pedestrian accidents. And so we're talking about a pedestrian involved with a vehicle, right?
Correct. Yeah, and so in North Carolina, those can be really difficult cases. And the reason for that is because of the harsh law that we have that's called contributory negligence.
Okay, what is that exactly?
In basic terms, it means the injured person in some way contributed to the situation that caused the accident and their injuries.
Okay.
And so under our North Carolina law, if that happens, then the injured person can't recover. But, you know, for every rule, there's always some exceptions to the rule. And so when an injured pedestrian calls us, we're looking for if there's a way to overcome that way, you know, that rule, the contrib rule,
okay,
that rule that the insurance companies are using to deny payment of benefits to injured persons. And so I've had a couple of cases of those recently. And so there's something called the last clear chance. And so that's something I've been working on.
Is that actually in the law?
It is. It's a common law rule, and so it's a way of overcoming contributory negligence. And so if you can be successful in demonstrating that the motorist, the driver of the car, had the last clear chance to avoid the injury, then the injured person can still recover.
You can still recover.
Correct. But, you know, it's very dependent on the facts. I mean, so no two cases are the same. So it's a very factually intensive inquiry, but that's what we're looking for. And if successful, then the injured person can still recover.
In these types of cases, we've talked about bringing in experts that you have as part of your resources with the Whitley Law Firm, that you have access to these people. You pay for them, I know that. They're not inexpensive, but they're crucial in helping you, right, in some of these cases. Do you use accident reconstruction engineers and people like that in these types of cases?
In pedestrian cases, sometimes, but again, it just really depends on the facts. And so when we're talking about last clear chance, I mean, you could use an accident reconstruction because sometimes the time distance calculation, you know, how fast was the vehicle moving, you know, to reach the pedestrian. So you might need an accident reconstructionist engineer in that regard.
Okay.
But for purposes of last clear chance and overcoming a contributory negligence jurisdiction, the key factor, well, the defense itself has 4 factors, but the key factor is whether the motorist had the time and the ability to avoid the collision. So, you know, thinking about in terms of pedestrian cases, you know, they either needed to see or should have seen that the pedestrian was in a position of peril and then had the ability to avoid it, you know, either swerve, take some, you know, try to avoid it, brake.
Some defensive maneuver or something.
Correct. Or in a particular case that I've done some research into, the vehicle was stopped, the pedestrian started moving, and so in that case, the time and means to avoid would simply be to not go. You know
just
what I mean?
Wait.
Exactly, to just delay your travel for a few seconds.
So in these types of cases, I think sometimes you deal with what they call incapacitated drivers, right? How do you define that? What is that?
Sure. Well, incapacitated or incompetent or somebody who shouldn't have been behind the wheel, you know, just in really basic terms. And there's a couple different ways that drivers can be incompetent. A medical condition. There are certain medical conditions, for example, a seizure disorder, or any medical condition that would prevent you from being able to exercise reasonable control over a motor vehicle when it's on the highway. And that's a matter of public safety.
Right.
So somebody who has that known condition and drives a car and causes an accident, they were incompetent. You know, you can be incompetent in other ways. Let's say CDL holders, as they have to...
Commercial driver's license.
Correct, I'm sorry, commercial truck drivers, you know, they have to undergo health screenings. We screen them a little bit more rigorously because they're driving 80,000-pound trucks on the highway with, you know, cars, and they can do more damage.
Right.
So, you know, if they don't pass their medical screenings, they could be incompetent. We also don't want truck drivers out there committing felonies with their commercial motor vehicles, because if that happens, they could lose their license and they can be incompetent that way.
Okay.
Or drivers can be incompetent by virtue of being impaired, you know, being under the influence of alcohol or another impairing substance.
Right, okay. And then I did mention before we went to the last little commercial break, you know, cell phones and distracted drivers too, as well. I mean,
it's another way that people can be impaired. You know, we look at studies now. It seems like the studies are showing that people that are drinking and driving, or people that are texting and driving, are even more impaired in their reaction time and their ability to look and see what they need to look at than people that are even drinking and driving. So these are all things that insurance companies can use against you, and that's why it's good to have attorneys that can fight, attorneys that know the law, and that can protect you, because they're going to use these insurance companies are looking for ways to get out of paying what you're entitled to. They're looking for it in every case, and you need an experienced lawyer to make sure that you've got your rights protected.
I mean, I was in it was a wreck that the other person caused and T-boned me and smashed at my car pretty badly and everything, but luckily I was okay and could walk away. The next day, the insurance company is calling and offering me $500.
Yeah.
I mean, it was like I called a buddy of mine who's a lawyer and I said, no.
Yeah, but this pedestrian, that situation with the last clear chance, you know, one of the things I was thinking about is, like, if you think about somebody that darts out into the road, very quickly they dart out into the road and they get hit, they're going to be found contributory negligent, and they're probably not going to recover. But if somebody was slowly walking out on the road and then stops in the middle of the road, maybe stops to pick up something they drop, then they may have the last clear chance because the driver could have seen them and had time to do something about it. Whereas in that first example, the driver didn't have anything to do with it. So that's kind of how that works. There has to be enough time that the driver could have done something about it. Very technical, very fact specific. It's why you need a lawyer. If you've been hurt as a pedestrian, the insurance company is likely going to deny your case, and you need somebody to fight for you.
And once again, at any time, you can call the Whitley Law Firm by calling the 800 number on your screen, or go to the website, whitleylawfirm.com. And also, you can email the attorneys there through the website, and one of the attorneys will be getting back to you through email, or they'll be giving you a call as well. When we come back, we're going to talk about what happens when people are injured through dangerous medical devices and the recovery process there. You're watching Attorneys on Call.